Ethicuties and the 40% of you who have still not subscribed to the Ethicsverse, welcome to the coolest place to be every Thursday at noon Eastern. If you think fixing our workplace can fix our world, I freaking love the Ethicsverse. We didn't have one this Tuesday, and I'm just kind of jonesing. So it's so great to be back. It's warming up here in Charlotte. So as we get started, drop your LinkedIn URL in the chat, like we say every single week. Your network is your network. Neither are big enough. Connect with someone today. Last week, we had a record-breaking episode, so thank you all who have shared the news and invited your friends and neighbors to the Ethicsverse. We almost broke 1,200, okay? Almost 1,200, and we almost broke our emoji record. You know, those are the two numbers I'm always looking at. So, so get those fingers warmed up, and let's try to break the record today. We're already up to 273, which is phenomenal, and I just started talking. So we got a real treat for you today. We're going to be talking about, we have former federal prosecutors. You guys love these guys. They are regulars on the show. They always come with a really great perspective, so we can kind of see inside the mind of the prosecutors, see inside the mind of DOJ, and we're going to be talking about the intersection with enforcement in education. So whether you're in education, whether things you touch intersect with education, or you're just curious to understand better the mind of regulators, this is the place to be. So as we get started, remember we are giving out tons of CEUs. I love sprinkling CEUs. I'm like the Johnny Appleseed of CEUs around here. We're giving out CEUs for HRCI, for SHRM, and of course the Compliance Certification Board, which we have been accredited for. So thank you very much. Very excited about that. And I'm very excited. I just got the transcript from my good friend Reed Blackman on his forthcoming book, The AI Nightmare, The AI Ethical Nightmare, which is coming out. I may have botched that title, but anything that Reed puts out, you're going to love. So if you have not read the first book that he put out called Ethical Machines, this is a great book. I'd highly recommend it. We're going to be giving away 5 of these today for those who are most active in the chat, asking the smartest questions, sending the most emojis, perhaps, okay? But this is, you know, we're entering this new age of AI. It's seeping into everything. More and more things are getting automated, and we need to have the right posture. We need to have the right mentality, and we have to have the right perspective on the ethical use of AI and how things can go wrong so that we can help our organization see around the curve. So if you don't feel like typing or you have a mouthful of food, because it is lunchtime for those of us on the East Coast, all good. Go to Amazon and go ahead and pick that up. And check out our year in review. We're gonna keep pushing this because I want to get some more mileage out of it. I think there's a lot of great content. I mean, who does more content than Ethico? Who adds more value to the marketplace than Ethico? Well, our year in review captures all of our toolkits from last year. We put out, I don't know, a dozen toolkits. We have a benchmark report. We have a bunch of things that you can pull from. So this, of course, is free. There should be a link on the console that you can click into to grab some of those resources and put those to practice in your program. Remember, in the age of AI where things are moving faster, in the age of, you know, in our current age where our responsibilities are expanding much faster than our resources are expanding, where we have a to-do list that we can never get through, we need to make better bets with our time, and we need to show up different. We need to show up in our organization as business people. We need to connect to the objectives of our organization, and we need to ultimately drive what's most important, which is the influence of the human beings in our companies. So check out the year in review. You're going to love it. I also want to highlight our smart disclosures. So you can't take action unless you have good information. And so much of our job is about getting risk intelligence from the humans in our organization. Even better, bonus points if you're able to turn the human beings into human sensors, right? Compliance is a human's business. We need input from human beings throughout the organization. And disclosures is, I'm just shocked as we've started to sell our new disclosures platform, how many conversations I'm a part of where so many folks have such a broken disclosures process, whether they're doing it manually through forms or through spreadsheets, or if they're doing it, you know, with one of these legacy tools that hasn't been updated in a while. So we have a bunch of use cases on the screen here for how you can leverage the disclosure platform for your organization, whether it's for cybersecurity, whether it's for incident reporting, whether it's for your standard conflicts of interest that maybe you're sending out on an annual campaign, or having a you know, an evergreen campaign where people can you know, report conflicts of interest or gifts in entertainment. So much of our job is really responding to disclosures of information. And when we can kind of zoom out and recognize that we need that risk intelligence from people in our organization, and we can create some of those channels to get more of that intelligence in real time, we, again, back to what I was saying before, can better direct our efforts towards the things that are going to really move the needle. We can't, what got us here is not going to get us there. And over this next 5 or 10 years within our industry, we have the opportunity to really kind of bend the curve. Pardon me, bend the curve on the influence that we can have. But it's going to start with you. It's going to start with you showing up in your business in a different way and making sure that you have the right tools for your team to make those good bets. All right, I want to talk a little bit about Dykema. You guys know these guys. If you don't know them, get familiar. You should follow them everywhere. Star this on your bookmarks. But tell us a little bit about Dykema for those of us who are joining for the first time, who are just learning a little bit about the Ethicsverse and haven't met you guys yet. 100 years, by the way. Wow. Tell us a little bit about your organization.
Jen, you want me to do that?
Sure.
All right. So Dykema is a nationwide law firm. We started in Michigan, have a large presence there, but we are throughout the United States now. We've got about 400 lawyers serving all industries, all the critical industries that you would imagine. Strong automotive presence, strong healthcare presence, things along those lines. But over the last several years, have really concentrated efforts on building a compliance and white collar defense practice group, which Jen and I are both a part of. She and our partners, Mark Chutko, as well as Leah Simonton, Tiffany Eggers, and Sarah Douglas. And we have a new presence who joined us out in Los Angeles, who's also a former federal prosecutor. So we are trying to take over the country in terms of building that presence to be able to respond to the needs that the clients have, whether it's building that compliance program, making sure things are good before an investigation gets going or too far down the road, or in dealing with and responding to that investigation and trying to minimize any impact. So amazing lawyers, an incredible group of people that care about the clients that they serve and try to deliver value in each and every matter that they handle.
Speaking of delivering value in every single matter, the last time we had you guys on, it was one of our highest reviewed episodes ever. So much positive feedback because the insights that you guys bring to these conversations are really, they're really top notch. So let's get a massive emoji explosion for Jen and for Scott. So happy to have you guys back. Jen's hair looks amazing. Scott looks more regal than I've ever seen him. My jawline here is really what I'm aspiring to be. But let's dive into our conversation for today. So we're going to be, I want to talk first kind of about let's kind of set the stage, right? We're seeing universities get hit from all sides right now with false claims acts, with foreign funding investigations, with grant freezes, all these kinds of things. So before we kind of get in the weeds, Jen, maybe I'll start with you and then I'll go to you, Scott. Can you give us a quick snapshot of your background as federal prosecutors and what that taught you about how the government in general kind of approaches these kinds of cases?
Sure. So I'm a former federal prosecutor from the Southern District of New York, and I worked mostly on complex fraud and cybercrime type cases across a bunch of industries, including higher ed. What I took from that is really that the DOJ, when functioning properly, is supposed to be out there making sure that they're the biggest threat actors, the biggest victimizers are really taken care of, whether that means in terms of dollar amounts of harm, who they're victimizing, the type of harm. That's what DOJ is supposed to be guarding against. In the current environment, we have to maybe think of some other factors, but really DOJ's job is to take out the biggest threats to our country in terms of fraud and abuse.
Okay. And, Scott is down in Texas and they've been getting some real chills down there. I think it was Jen was saying that it was like in the 60s, everybody was bringing their plants in. So Scott, that's maybe the biggest top of mind threat. But what would you add to what Jen said from the context of your background?
Yeah, absolutely. So my background was largely in the False Claims Act and doing affirmative and civil investigations across all spectrums. So I dealt with cases that involved the education industry, as well as like grant fraud, things along those lines. And I agree with what Jen said completely, right? That the DOJ's mission is to protect and to prosecute those who are taken advantage of, from my end on the civil side, taking advantage of the federal fisc, whether that's grabbing grabbing grant funds that they should not have gotten, or getting a hold of monies in other ways, whether it's procurement or whatever the case may be, that they shouldn't have. So they should be there to protect and then enforce, because a grant fund taken by University A that they never should have obtained is actually taking it away from universities B, C, and D, right? So the goal was always to try to make sure that the appropriate people were getting the funds that they should receive, as well as making sure that they were using them properly on the back end.
So let me stay with you, Scott, for a quick sec. Is this current focus on universities, do you think this is like a genuine shift in DOJ priorities, or has it always been there and we're just seeing it more publicly now?
I think it is larger now than it has been in the past. I think it has always been there. I would say that university cases were more of a one-off than a constant presence, but I do think they did happen. Especially in the grant fraud realm, just because so much of a university funding, it comes through grants. And so a lot of times they would come about through whistleblowers, as opposed to more of the maybe headline-inducing investigations that I think that sometimes that we see today. So they've been there. I think it was a smaller presence. We didn't have the DEI as the investigations or the new exciting thing that grabs all the headlines. Obviously, those weren't a presence in years past. But yes, there have been investigations, but I do think it has expanded under the current administration.
Yeah, you didn't have Elon Musk whispering in everyone's ear. So Jen, over to you. For compliance executives, I'm going to call you guys all compliance executives now, okay? For compliance executives who are tuning in, who maybe they don't have a legal background or they've never been through a prosecution, can you just explain briefly, 60 seconds, how does a federal investigation even get started? Does somebody file a complaint? Does DOJ just go looking for problems on their own? What does that look like?
Yeah, so a lot of investigations, corporate investigations from a higher ed institution start with a whistleblower who either goes to an agency like the FBI or to a U.S. Attorney's Office or DOJ directly. Sometimes DOJ is proactively looking for investigations. They're reading the investigative reporters, looking at the headlines, seeing whether there's something they should go out and proactively investigate. So it really can come from both of those sides. Some of the bigger offices like SDNY, where I worked, we had internal investigators who were really out there proactively looking for things to start. But I would say 95% of the cases are coming up to DOJ through an investigative agency like the FBI or the Department of Homeland Security. And they're getting their tips from, they've got online tip reporting, hotlines, whistleblowers, all of that. Sometimes it's aggregating those tips. Maybe you got 20, 30 tips about one situation, and that's what brings the headline. Sometimes it's the amount of money involved, or is this a politically sensitive area? Something causes that investigative agency to push it up to the Department of Justice.
I see. So it just kind of trickles on up based on the work from some of those other folks. So Scott, let me ask you this question. When does the DOJ decide to go criminal versus civil versus just administrative action against a university? What kind of drives those types of decisions?
So it's actually an evaluation of the case and what's happening, right? So if you've got, for example, let's say a case initiates from an audit that an IG does, right? A Department of Education audit that the IG then brings to the U.S. Attorney's Office or the DOJ. They'll start digging into it more to try to find out if, in fact, okay, do we even have a civil violation? Do we have a False Claims Act issue here? Or even worse, do we have a criminal matter that should be going forward? So a lot of it will be like individual conduct, and for those criminal implications, right? Do we have this knowing intentional conduct that's occurring that they're looking to steal from the feds? Or do we have more of a technical, regulatory, that type of violation where maybe there should be a False Claims Act inquiry, or should it just stay, as an administrative matter that gets resolved without the DOJ's involvement? So it's going to be driven by the case, what the facts are in your situation in that investigation that's going to really make the call or the determination as to what road it's going to go down. And sometimes, and this is, I know for a lot of folks, worst case scenario, it can be both. Right? You've got a parallel investigation and a parallel prosecution where the criminal division may prosecute individuals criminally. The civil division may go after an entity for specific funds, or there could be even a separate administrative inquiry and or proceeding.
So Jen, you ran criminal investigations. Maybe you can add a little bit more color. But what makes something criminal versus just a False Claims Act issue? Like, is there a line? What is that line?
Yeah. So, in a civil case, you have to prove your case by a preponderance of the evidence, which you can think of as like 51%. In a criminal case, you have to prove it beyond a reasonable doubt, which you can think of as 99%. So certainly for something to become criminal, a criminal prosecutor has to be convinced that there's really overwhelming evidence of the person's intent, that they really intentionally, with knowledge, willfully committed this criminal act. You need that to prove a crime. So that's one of the big factors that pushes it across the line. Another one is the severity of the conduct. A lot of times an indicator of that is this a repeat offense? Maybe there was a False Claims Act case or some other civil action, a class action, whatever, and this university or other company isn't getting the picture. That's a factor that will push it across the criminal side of the line. We really need to see more serious consequences. Obviously, in the criminal system, we can't put a university or a company in jail, right? So most criminal cases are actually against individuals at those entities. So another factor is, are there really individuals who are responsible for this conduct? Can we tie this conduct to an individual or two or three? You can charge a company or a university criminally, but you can only resolve that through fines. And so it's just a really different use of the criminal process that is more rare. So this individual liability or culpability is one of the big factors that pushes it on the criminal side.
Interesting. Scott, DOJ recently said that compliance certifications are material for False Claims Act purposes. What does this mean, like in plain English? Why should, the audience care? What does it mean for them? And why should universities tune into this distinction?
Yeah, so materiality is actually an element to be successful, that you have to prove to be successful in a False Claims Act case for the government. So, and what materiality basically means is the government would not have given the money if, in fact, this, condition X had not occurred, right? So it was important to get the money. By them declaring all of these things are material, they're basically taking that defense out of a university's or, a corporation's hands of saying, well, this wasn't material to a payment decision. We saw a lot of that argued through my years in the DOJ. Well, this wasn't material. It didn't matter. This is just a minor infraction. By saying all of these compliance requirements are, in fact, material, they're removing that defense so that it provides, basically a cleaner track for the FCA prosecution.
So for those of us who struggle with this materiality concept, we don't have to really worry about that anymore. Materiality is out the window. By their nature, the violations are material.
Yeah, that could be tested in the courts, right? Because you can say it, but then if you put agency personnel on the stand who say, oh, no, we wouldn't have mattered. It wouldn't have mattered to us. We actually don't care. Then you've got a real question there of, well, is it in fact material, or was that just someone labeling everything as material and it wasn't actually material to the government's payment decision? So I'm not sure that has been completely worked out, but it certainly is going to make it more difficult for a university or a corporation responding to an FCA prosecution.
Let's get a round of applause for Scott, because it's so nice being not the only guy in a suit and tie on the Ethicsverse. So thank you for that answer, Scott, and thank you for that nice tie knot you got going there. So we've heard a lot about this.
Court, Nick, so it wasn't for you, buddy.
Just lie to me, will you? You can lie to me. That's all right. So from like the government's perspective, how does the involvement of a quitam relator change the trajectory of a case? Does the DOJ treat like a whistleblower initiated case differently than one that they develop on their own, or one that kind of bubbles up through some of those other channels that Jen was talking about? What do you think about that, Jen?
I think in a lot of False Claims Act cases, frankly, the issue comes to the government's attention through a whistleblower or quitam relator a lot of the time, because the government's not inside these companies. These individuals are inside the companies and they have that information. So it can be a plus factor, I think, for the government that they have this insider giving them information. The problem is there's so many people that are relators bringing up so many things that the government really has to act as a filter to figure out which ones of those are viable or not. So, I think that's a good way for them to get information, but they get too much information, frankly. And then people like Scott, who used to work in the government, have to filter through that and figure out which ones are the best. building up the case yourself from the government side obviously lets you know that you have used credible information and tactics and techniques. You don't know that much about the relator necessarily. There are law firms out there that are really full-time relators counsel that maybe have a good reputation. Maybe you know that if it's coming from some of those firms, maybe it's more credible than some other relators. So that can be a factor as well.
And let's get a round of applause for Jen, because she's so graciously corrected my pronunciation of that term, which I seem to say different every single time. So thank you for that.
Let's hope that my pronunciation is correct. I don't know. Oh,
this is what wide open. Okay, well, I guess I said it. I guess I say it right every time. So Rashimi has a good question here. They say, how does DOJ filter at intake? So all this stuff is coming in. What's that filtering process look like?
They don't filter on intake. You have to actually review each and every matter, right? You have a duty to investigate the qui tam as presented. So now some of them on their face, obviously, you look at them and you are very suspicious and think that this investigation is going to go away probably fairly quickly. But the main thing that will occur is if there is any type of credibility, unless it's just completely frivolous nonsense, right? They will interview the whistleblower. That's the first step to evaluate whether or not there's any credibility to the allegations that are being brought. So they'll conduct that interview long before anyone else knows about the case or any documents are requested or anything along those lines, unless you've got like a patient harm situation in a healthcare scenario, right? Then they're going to act differently. But normally they're going to interview that whistleblower and find out just really, are they dealing with someone who is just a disgruntled employee who got disciplined or terminated and they're really angry? So they filed this out of retaliation, or is this someone who actually has some inside info that there could be some wrongdoing going on with the entity? That's really the biggest screen from the get-go. And then you will figure out what steps you're going to take, whether you're going to start requesting documents from the other side, or if there's some additional. You can go to the audit side of the agency house, the IG, and see if they've done any audits, see if there's anything that backs up kind of what the allegation is from the audit perspective, or if it's just complete nonsense.
So here's a great question from Nicole. Nicole, thanks for this question. She says, are public universities treated differently, or are there limitations in prosecuting public universities because they are a government entity? Jen, what do you think about that?
Well, so first of all, public funding is a big factor. The more public funding you're receiving, the more susceptible you are to False Claims Act cases and some other criminal cases for use of that public funding. But private universities also receive public funding, frankly, so that doesn't insulate them fully from the risk of prosecution. There can be obviously some government actors, including public universities, can have some degree of insulation from lawsuits for certain conduct. So you do have to think about whether there's some kind of issue there. Can they be sued for every single thing that they do? Maybe not. That's an issue to look up. But from a government investigation perspective, it's really all about that public funding and whatever conditions are, attached to that grant funding or to Title IX funding, whatever it is that you're receiving. That's really the big factor for government involvement.
So we kind of scratched the surface of this before, but Jim just asked. Jim, thanks for this question. What are you seeing in terms of trends prior to the past year, and how has that changed over the past year? How would you describe that? Maybe we'll start with you, Scott.
I want to make sure I understand the question. What kind of trends that I've seen before the past year?
I think let's use the past year as just kind of a,
an anomaly
sketch for like the new administration, let's say.
Okay, right. Yeah. So the trend was always on the healthcare side of things, right? I do not think universities were, trending up. I do think grant dollars, because we operate from a government perspective, it's such a large deficit, right? There's always going to be a desire to, one, protect national security. So that's where universities, I think, have run into some issues with who's funding them, who's funding researchers that are present, who's funding faculty, things like that. So national security interests are always going to be at the top. Then I think you're going to have the size of money involved, right? Or that's going to be implicated is going to be a huge player in what drives the trends. So that's why healthcare is always going to be such a huge trend. The amount of Medicare dollars, Medicaid dollars, it's going to be a huge priority for the DOJ, and has continued to be in this administration. So I think those two things kind of were always the biggest players that were going to be present. And then kind of just how industry evolves and what we see. Like there are some years where you'll see a number of like DOD procurement fraud cases that are giant cases that that the department recovers on, but those are kind of fact specific, and they're always going to be a priority when the department learns about them. So I would say national security, healthcare, and defense were always the biggest ones. And I think education now, folks are realizing how many dollars are involved. And so I think it's become more of a target as well.
So Kevin just asked a kind of a clarifying question. I think it was back to something that you said a couple minutes ago, Scott. So he said, "Hey, Kevin, how's it going?" He said, filing a whistleblower submission are retaliation because the member of the staff is, quote, trying to get back at the employer. I'm very nervous. The only relevant question is, does the concern represent a genuine concern? The motivation is irrelevant. Can you kind of clarify that? You were just kind of saying, like, is this a spurious claim or not?
Correct.
Is that kind of what you're saying?
So there are some who are just acting out of spite, right, or anger, who will try to allege some type of violation of the False Claims Act, just in retaliation against, not a retaliation claim against their employer, but to retaliate against the employer for any type of action that they took against them. So we never looked at the motivation as it impacted the underlying claims, but you would look at, do they even have a valid claim, or is this just, as you said, a spurious allegation to retaliate against an employer who has taken some type of employment action against them?
Okay, cool.
Does that help? Does that clarify?
Helps me. Yeah.
Okay.
And I speak for Kevin, so yes, it helps us. So
perfect.
Jen, question for you. How are you feeling? You ready for a two-parter?
I'm sure. I'm ready.
Okay. So let's pretend that you're a compliance officer and you hear your university is like under investigation. What do you think the first thing you need to do? Like, what's the first thing you have to figure out? Is it civil or criminal? Is it something else? How do you even know? And that's part A. And then the second one, and this sort of second part of the question is, how does the response change if you're in the same situation but you're not at a university?
Okay.
Is there any different kind of response?
Yeah. So for a university,
okay.
Well, for any situation, including a university, the first thing you have to do is triage the risk presented by the investigation. An investigation can be tons of things. It can be an HR complaint against an individual employee, and the only outcome could be, maybe this one person gets fired, in which case your only real legal risk is you might get sued by that employee. Or it can be some, allegation that you took funding improperly from the Chinese government, which is obviously a very serious national security risk and could involve the government. So conduct that triage process first, figure out where you fall on that spectrum. The most serious risks need counsel involvement for a variety of reasons. One is because your counsel should always be interfacing with the government. Another one is because you need attorney-client privilege so that you can conduct that investigation with privilege attached, so you can figure out how to operate and how to, when and how to go to the government. The second part of the question, university versus private company, I think the only difference really is there are some specific laws and requirements that apply to universities that don't apply to other companies in terms of how that federal funding is allocated and what you have to do with it and what you have to do to comply. So part of that triage process for universities needs to be whether any of those laws are implicated. Otherwise, okay. It's pretty similar. An investigation is an investigation, and you have to figure out what legal risks attach to it.
So kind of double clicking on that, I'll start with you, Scott, and then Jen, of course, if you want to add anything to it, please feel free. But what do you think some of the warning signs are that an administrative or civil, inquiry is kind of escalating toward that criminal territory? Are there some red flags? Are there some tea leaves to read where a compliance officer can kind of watch for some of those signals to kind of let them know or let them realize that the stakes are getting higher?
It's a great question. Well, obviously, if you get a grand jury involved in any way, it's completely shifted, right, to criminal, right? Civil
Okay.
folks cannot use the grand jury. So if you get a grand jury subpoena, yes, the road that you're on has changed dramatically. Oftentimes, the players can change also, right? So depending on what office you're in around the country or what region you're in, a lot of times the FBI will not stay involved in something that is going to be strictly civil or administrative in nature, right? They tend to focus their efforts on criminal. That's not true everywhere, so you can't take that as, okay, that we're good, the FBI is not involved anymore. But in a lot of regions, the Bureau doesn't feel like they have the personnel to support it. So that can also be something that can be significant. I also think anytime if you start hearing of Fifth Amendments, Miranda stuff, folks start using words, subject, target, things along those lines, your tentacles have to go up, or your antenna have to go up, because you're now in a criminal realm versus playing in the civil world.
Okay. Anything to add there, Jen?
Yeah, I would add it if government agents start coming to the university and talking to a bunch of your employees or going to their houses and you hear about it, the more involvement like that, the more likely it is to be on the criminal side. Also within U.S. attorneys' offices or within the DOJ, there's certain units that are more civil and certain that are more criminal. So if you consult with counsel, they're likely going to know what side of the line you're on, depending on who's calling you or who you're interacting with. So, that's an important thing to know in that triage step.
Yeah, getting some of that insight, so you're not just kind of flying blind. So to kind of sum up this chapter of what we've been talking about, it seems like a criminal case, we need proof of intent. So somebody needs to have known that they were doing something wrong. False Claims Act is, even if it's unintentional, it's just really about false claims for federal money. That's kind of what I've kind of boiled it down to. What do you think about that? There
is an intent requirement for a False Claims Act case to be successful. It's just much lesser. Yeah, it's just much lesser than the criminal side, right? So it's
back to that 51%, 99%. Yeah. Okay.
It's a reckless disregard is the standard under the False Claims Act. That's the minimum standard of intent, is reckless disregard. Whereas on the criminal side, it's knowingly, right? So
cool.
there is an intent element, but it is much lesser.
Okay. See, we're all learning together. I love it. All right. So let's get into kind of, inside a university investigation, because I think there's, a lot of kind of principles that are applied, as Jen was saying, a lot of principles that are applied from DOJ or from a prosecutor are going to be very similar, whether you're in university or elsewhere. So let's say a university is notified they're under investigation. Maybe it's from, Department of Education. Maybe it's from DOJ. Maybe it's both. Walk us through what happens next from the prosecutor side. What are they lining up? What pieces are they going to be looking to start moving on the chessboard?
Yeah, so it's never that when the university finds out, that's not the start of the investigation. Before that happened, there will have been a bunch of subpoenas issued. The prosecutor's trying to get their ducks in a row and make sure there's really some there. If there was a whistleblower, they've interviewed them. They've probably talked to some other folks. They're convinced now that there's at least something worthy of their time to investigate. So, when they go to the university, when they become a little more public with the fact that they're involved, that usually means they want to talk to people that still work at the university. They want to get documents, maybe execute a search warrant, something else that they don't have access to using those more covert means of investigation. So once you know about it, you're probably going to see more interviews lined up, more requests for documents. University involvement and cooperation is definitely going to be expected at that phase from the prosecutor's perspective.
So that kind of leads me to my next question. This term cooperation, what does that actually look like from a prosecutor's perspective? What can help a university or anyone really make things better or make things worse? What do I'd like to start with you, Jen, and then we'll go to you, Scott.
Yeah. So there's DOJ guidance. If you think you're going to confront this issue as a compliance officer, I would say, Google DOJ cooperation policy and definitely read it and read the factors so you understand thoroughly. But a high level summary is basically DOJ expects you to be proactively cooperating. So in a best case scenario, if you find out about an issue that is a federal criminal violation, DOJ would want you to go self-report it to the appropriate government agency and provide the documents and witnesses necessary for the DOJ to evaluate that case. What DOJ policy says then is that if you do that, if you meet those cooperation factors, which I'm simplifying, then you get some credit for that cooperation in terms of a lesser penalty, or, maybe they're not going to put it over the criminal side of the line for either the university or the individuals. But this is definitely not a one-size-fits-all analysis. You should, if you're thinking about these kinds of issues, you should consult with counsel about whether and to what extent cooperation is actually going to be helpful to you in this environment with this type of case. There's probably some things right now that are such hot button issues that if you go in and self-report them, it's not as certain that you'll get cooperation credit or benefit. That's not just for political issues, it's for everything. So it's a time where you should step back and say, we should figure out what's best to do.
Yeah, this is not like the time to reinvent the wheel or just kind of wander through it and figure it out as you go, kind of to your point. I mean, we're kind of just scratching the surface on the depth of knowledge that, you guys have and that your firm has. This is not meant to be a Dykema commercial, of course. Wink.
That's okay.
I'm kind of kidding, but I'm just saying, how the machine works, the inner workings, what kind of things, they're going to be looking for, or that, can be kind of strikes against you that you might inadvertently kind of stumble into on your own. You've walked these paths kind of from both angles. What would you add to this, cooperation conversation, Scott?
Yeah, I think Jen hit the nail on the head, right? I think you have to engage counsel now more than ever. In situations past where you might have just gone in and sat down and had a meeting and shared everything you've learned and documents that you have that you think might be helpful, I think that's a riskier situation today. And so I recommend absolutely getting counsel. And it varies prosecutor to prosecutor. Some actually don't love cooperation because they don't trust it, right? Depending on the prosecutor that's involved. Other prosecutors would love to just sit down and have you basically open your books and tell them what you found through your investigation. So it can be, some of them they'll all take the meetings, they'll all hear you out, but others may rely on it more than someone else would. So it in terms of insights, it kind of varies.
Well, I think, I don't know, this is either kind of like a threat or it's an opportunity, depending on how you look at it, the sort of subjective nature of the perception of cooperation and the value of that quote unquote cooperation from the prosecutor's perspective. To your point, some people are going to just not trust anything because they're maybe, maybe somebody hurt them. Okay. Maybe they didn't get enough hugs when they were little. Other people are going to kind of, be more collaborative in that, and you might get more credit. I think that's very freeing because, back in my audit days, at the end of the day, there's, in audit from a financial perspective, I think there's a corollary here. But like a financial audit is, meant to be a very objective exercise. But there's so much subjectivity kind of floating in there. And we're all human beings at the end of the day. We've all read that book, Thinking Fast and Slow by Daniel Kahneman or Kahneman, depending. I don't know. I've never heard his name. I've just only read it. But, there are these two systems in our mind, and this one below the surface where so many of our decisions are actually made in this sort of subconscious level. That's at play for everyone, whether they're a prosecutor, an auditor, or whatever. So I think if there is and correct me if you think I'm off base here, but I think if there is a genuine sort of good faith effort to be, fine, read the guidance, but if there's a genuine good faith effort to be cooperative, the odds of you kind of getting credit for that, with counsel advice and all that is probably going to be a lot higher than trying to kind of gamesmanship your way through it.
Yeah, I think that's fair. The prosecutor is a person just like any other person, right? And they can get a sense for whether this is genuine cooperation or not. I do think that factors into it. And certainly so does who's sitting on the other side of that table, in the way Scott says. It's a far more subjective analysis of the law, I think, than on the audit side. At least on the audit side, you have numbers which are a little harder to manipulate than standards like reasonableness and intent and things. You might tell me different.
Well, that's a very lawyer perspective. They're just little lines on a page. Okay, you can manipulate anything. But okay, so I want to kind of talk, back to the kind of the university discussion. We saw Harvard, Penn, Berkeley all get investigated for different things. how do prosecutors kind of juggle multiple agencies looking at the same school? Like, what is there any kind of traffic jam there? Is there any considerations that a prosecutor needs to kind of juggle?
So they will use. Oh, go ahead, Jen.
I was just going to say there's some backdoor interagency stuff that usually happens before you get that first call from whatever law enforcement agency it is, where they try to hash some things out and decide who's going to take the lead on this particular investigation, usually. But then there's some things that always run in parallel. This isn't a great university example, but for example, the SEC will often run an investigation of a public company at the same time that DOJ is doing that, and they're going to be in parallel. Might be true for the IRS and some other agencies too. So usually they've hashed a lot of that out before you meet with them, but sometimes several people are at the table at the same time.
Okay. How about
a lot of it can depend on the grant fund. Yeah, a lot of it can depend on grant funds as well. So if you have a grant fraud type situation for a university and they've received grants from the Department of Education, let's say a scientific NASA grants as well, you can have a number of investigative agencies all being at the table, right? But the prosecutor will be the lead, and they will all support that prosecutor's efforts. So the prosecutor will kind of be the traffic cop to make sure that there's not over duplication or things along those lines being demanded.
So let's talk about the role of individuals. We kind of touched on this a little bit earlier, but I'd like to kind of double click on it. So when a prosecutor is investigating a university, are they primarily focused on like institutional liability, or are they also focused on looking at individuals like deans, department heads, compliance officers for personal liability? Does it depend? Like, what does it depend on?
Criminal prosecutors are mostly focused on individual liability, frankly. They might try to leverage an institution or a university to try to get to those individuals, but what they're really trying to do is make sure they're taking care of the risk presented by these individual threat actors who have, traditional criminal penalties like imprisonment, probation, et cetera, work on those individuals. I think Scott will tell you the opposite on the civil side of the scale, though.
I agree with that. Unless you have an individual who's been siphoning off money, things along those lines, where they've got, some type of individual liability, normally the civil side is going to be focused on the institutional liabilities. And part of that is just the practical reality of, would you be able to get that money back? So going after an individual who makes $80,000 a year, but there's been this grant fraud and there's been, there's $6 million lost. What's the likelihood that you're going to be able to get the $6 million out of the individual? It's pretty low. Now, you may seek to hold that individual liable as well under the False Claims Act, just for purposes of deterrence and individual accountability, that kind of thing. But you're going to focus on where you can recover those funds for the fisc. So I agree with Jen that you may have both on the civil side, but it's going to largely focus on the organization.
Another question here. Does a relator have to report to all agencies involved, or DOJ is just the main agency to report to? What do you think about that?
DOJ. That's DOJ. The focus. Okay. You've got to report. If you're going to be a relator, a key term relator, you've got to file, and you've got to file the lawsuit, and you've got to serve it on DOJ. DOJ will then reach out to impacted agencies to the extent they can and advise them that the key TAM exists, see if they want to assign investigative resources or agents to it, and come to the party.
I one time heard this guy say Quitam. It's key TAM, dummy, All right.
It depends on the region.
It's just the region. Okay. All right.
In Texas, it's key TAM with a long A.
Key TAM. All right. Well, I like it. Texas does it right. So I want to talk a little bit about some actionable advice. There's always this concept of documentation. What role does that play? How important is that to get your ducks in a row? Can you explain what prosecutors are typically looking for? I'll start with you, Jen. In that first round, what documents tend to matter most? If there are, it may totally depend, but I'm just kind of curious, what as a compliance officer do you have to absolutely have super dialed in?
I mean, the most important training you could do is training your people on email and text messaging etiquette, right? What the prosecutor is always looking for is that smoking gun And there are so many times where there's an email or a text message or something that says, we're all going to jail, literally that clearly. So training your people on what not to put in writing is a very important step to take from a compliance officer's perspective. Jokes aren't funny when they end up on the prosecutor's desk. And there's a lot of times where, if you're looking at an after the fact recorded, documentation of something, it's really easy to take that out of context. Prosecutors are just people, as we said before, right? And you see some of these like highly charged phrases, it gets your juices flowing. You want to go after that company or university more. So it's hard. It's hard to get that across to people, but really just training that bad etiquette out of them is the best step I think you can try to take.
Yeah, so the "I was just kidding" is not really like a valid defense.
I was just kidding is not a very good defense. Yeah.
It doesn't work.
All right.
Nick, one of the big things to me is having the policy is great, but you need to have documentation that you pushed it out and trained people on it as well, right? A policy that you've just drafted and then put on the shelf and everyone knows it's there is not going to be all that, let's say, compelling to a prosecutor if no one's ever trained, let's say, new employees in orientation that we have this policy and this is what's expected, or if there's not some type of annual refresher, or if they get new sign-on authority for specific funding authorizations that they haven't been told what that requires, or they're authorized to sign grant applications and what those requirements are and what the expectations of the organization are. If they don't do more than just draft the policy and put it on the website, I'm not sure that it's going to be all that moving to a prosecutor. At least it wasn't to me. I should speak for me. It wasn't to me.
Well, you can speak for all prosecutors if you want.
No, that's okay.
But I'm kidding. I'm just kidding. But I think kind of to the broader point, again, I'm trying to like reference, an experience I've had directly, where like you come into an organization, you're doing some kind of an audit, and there are some lacks of controls, right? At some level, back to the subjective nature of it, you're trying to like gauge, like, do you even see that this is a lack of controls? Like, do you see that like this thing is not working? Do you have sort of compensating controls kind of around it where maybe it, like kind of conveying that, yeah, we've thought through it and it's not a material risk for us or something, right? Like, as opposed to somebody just like flying blind and, kind of being sort of asleep at the switch. And kind of that circles back to a point that you both kind of have made, that good faith effort to say like, okay, if we have this training, we're actually trying to make sure that this training is doing something, i.e. influencing some behavior, as opposed to sort of checking that box. I think it's a very human thing. I mean, again, we're human beings dealing with other human beings, whether they're on the DOJ side or whether they're stakeholders inside of our organization. And we're always trying to kind of sniff out like, where's the BS and what's genuine and authentic. So I think that's great advice. We have a great question here from Tina. Can you give some examples of where we can gather resources on training what not to put in writing? Is there a heuristic or a rule of thumb, or do you have a couple of examples or maybe a resource to point to where we can get a better idea of what not to put in writing?
Yeah, I mean, other than giving the council commercial again, I'm not sure of a resource to go to, but a lot of these things are common sense. Try to have your people state of facts and not opinions. Use email for what it's intended to be, your workplace, communications. We hopefully are past the time where we're sending insensitive jokes and things in email. But, again, a lot of what we're seeing is really what should have been a private communication. But we're getting away from a time where people are picking up the phone and calling people. And so more things are in writing now. Mm-hmm. So, just telling them, just because you put it on WhatsApp or Teams or whatever, doesn't mean it's going away and it isn't going to be preserved. All of those workplace communication methods could be looked at by prosecutors. So, just encouraging them to keep things factual and not opinion. And if you really need to vent to your coworker, call them, even though it's 2026 and no one wants to call anybody.
I mean, it's so obvious, but it's such a critical point, right? Like with all this new connectivity, all this new, efficiency that can come from the way that we message, we're just creating more and more lakes of like discoverable things that can, be framed in a way, or maybe can be evidence of some wrongdoing that can get us into hot water. I think there's a lot of great training that can be done around those kinds of communications. I mean, the worst thing you could do is shoot yourself in the foot and kind of like, I don't know. There's a lot of great sort of training topics on that. So I appreciate you sharing that. So many great comments.
Don't blame.
Yeah, go ahead.
I can throw just one of the things that I think has always been a problem. Don't just assume you know what happened and assert blame in an email, because a prosecutor is going to grab that and use it, right?
Yeah.
Assumptions just get you in such trouble, because once it's in writing, it's there forever. And
that's a great
prosecutor
point.
and an agent's going to get it. And so if you have an open question as to how something went wrong, like Jen said, pick up the phone, ask, worst case scenario, if it has to be an email, if they're on the other side of the globe or whatever the case may be, right? Ask questions. Don't just start putting accusations in an email, because agents and prosecutors are going to take that email and run with it.
Yeah, I mean, so many people in their day-to-day, they're not thinking about that kind of stuff, right? They're trying to, get through their email. They're trying to sort of preserve their own jobs, like whatever that Maslow's hierarchy of motivators are. So many people are just not thinking about it. And back to Jen's point, there's this like plethora of this information out there. Wendy made a great point. Our personal sage, Wendy Badger, said, for training, it's important to keep in mind that completion rates are not the same as comprehension rates, or whether the training was effective. Apart from Hotline or other reports that were investigated, and there were consequences, what other than training completion rates is effective to show that the education was effective and comprehended? So again, let's say a prosecutor's coming in, back to your point, Scott, about like not just having a training that's sitting on the shelf. What do you think some pieces of evidence that somebody who, let's say they're doing that good faith effort, they're not just trying to keep it on the shelf, what could they point to beyond completion rates, which to Wendy's point, really kind of don't mean anything, right? Because you can click through that or have your assistant do it, or even AI at this point. Have Claude click through your training. No, don't get any ideas. What are some things to point to kind of validate and kind of confirm that, hey, like we're putting a good faith effort toward the training. Here's kind of some proof that got me comfortable that I didn't need to double down on that training or something like that.
Sure. Well, you can look at patterns and practices. How do they do it every day, right? Can you show that in fact they have followed the procedure, and this one person just screwed up? Mistakes happen, right? The department knows that because they all are our prosecutor, our people as well, right? So if you can show that we have this system in place, and look, it is utilized all the time. This one individual, in fact, just screwed up and forgot to do it this time. That is obviously significant, and I think will really register with people. It also, at some point, you can lead the horse to water, but can't make them drink, right? There's only so much you can do, and that can lead to a shift in organizational responsibility versus individual responsibility. So the organization, you as the compliance officer, all you can do, you can put it out there, have the training, maybe do the occasional spot check in, audit kind of thing of, are we doing this? Are we making sure that we're doing everything we can to comply? And if they refuse, that, at least from the organizational standpoint, you may be fined from a liability perspective, but that individual who has refused to follow, and it may end up shifting into more of Jen's lane, right? Of this could be where we're getting into some type of intentional conduct that could lead to more of a criminal inquiry.
Yeah, and can I just add one thing to that one, which is,
please,
you can use your annual evaluation process as a way to put a real check on these things. Your employee evaluations need to be real. They can't just all give everybody an A+, because for a lot of reasons. One is you might have issues with chronic employees that are going to turn out to be whistleblowers, and then you don't have any means to punish anyone because you haven't laid a foundation for that. And if somebody becomes a whistleblower, it's going to look like retaliation if you just have sort of A+, everything's rosy evaluations. Another one is that is a good way to have your supervisors actually evaluate on things that are important to you. So if email etiquette and making sure things stay out of writing is important, it should be in the evaluation, and people should actually be evaluated on, is he saying silly things in his email or not? That's a way, I think, to put a concrete check on this.
Well, it at least closes the loop, and at least at some level sort of signals that there's some incentive which is kind of the precursor for all behavior in my mind, there's at least some sort of incentive structure in place to validate or confirm or at least promote the types of behaviors that are more toward the sort of compliance side of the fence,
Mm-hmm.
Okay, so man, there's so many good questions. Let me ask this question. So Cheryl, thank you for this question, Cheryl. How are AI generated items being handled versus emails, documents, et cetera, solely generated by human beings and employees? And I'm assuming kind of in the context of some kind of an investigation. Is a different weight placed on those? Is the existence of them sort of at the same level of like validity or evidentiary sort of value in an investigation? How are folks starting to think about that?
Yeah, I think the government moves a lot slower than private industry when it comes to technology use and implementation. So in terms of, DOJ investigations, I think the first thing is they haven't fully thought through how they're going to use it or think about it probably yet. There is some thought being put to how do you determine culpability of some individual? What if the AI really is what screwed it up? Now, how do we go back and figure out, is that the university's fault? Is it an individual's fault? Is it the person who wrote the algorithm that underlies the AI's fault? So they're trying to ask those questions right now. I don't know that there's really institutional answers yet. It's an evolving area for sure.
Okay. So let's kind of pivot back to the university specific discussion here. So we saw Stanford, we saw Delaware and Columbia settlements kind of creating sort of a blueprint. Can you give us a quick overview of these cases and like, what do you think universities should learn from these cases? What lessons can we gather from that? Let's start with you, Jen.
So, I mean, I think the biggest lesson for universities to learn is, what's the saying? A pound of prevention is worth an ounce of cure. Compliance is really important, preventing these issues. Once you're in issues, we don't see very many situations where a university is either sued or investigated by the government, and then the government says, you know what, just kidding. There's not going to be a resolution. We're not going to impose a huge fine. So you really need to spending that money on staying out of the highest target areas is really valuable, because once you're in it, your options are really go to trial or settle. It's probably not going to be, oh, let's just convince them that they're wrong about their theory. That happens sometimes, but it's very,
rare.
very rare.
Yeah. What would you add there, Scott?
I think especially as it relates to grants and things like that for universities, the funding and the connections to other countries like China that are just the hot button topics is going to get great scrutiny at all times. And so I think you've got to flesh that out on the front end, and don't just take a professor who is maybe over a visiting professor or whatever the case may be, who just signs the form and sends it in. Don't just turn a blind eye and say, well, he said it, so we're good, because the organization could end up having the additional responsibility by sticking their head in the sand.
Okay, so I have like two more questions here. Well, I have more, but I want to ask this question here. So let's say you discover your university made a false certification 6 months ago. What do you do? Is there a way to fix it before it becomes a federal or a False Claims Act case?
Well, sure. You can try to correct it with the DOE on the front end, right? And so if you learn of it, that's where you would want to go to DOE and find out, okay, who is it that is responsible for this? This is what we've learned. This is what we've done. And try to keep it on the audit side of the house, right? Before it ever becomes part of an investigation, so to speak. Things get a whole lot worse when they turn into an investigation. So if you learn of some type of false certification or issue, I would get with counsel, get a game plan together, right? Have a full narrative, full set of facts, and approach the regulating authority and say, okay, here's what we had certified. Here's what we have since learned. We did not know at the time. This is the corrective action we've taken to put in place. Obviously, we wanted to let you all know so that it didn't become a question where you all thought we were trying to hide something in the future.
But obviously, like, it can be in-house counsel, but counsel needs to be first, because we can't undo that. We get a lot of calls where it's like, we called DOE, we told them 5 things, now they're really mad at us, fix it. That's a
Right.
lot harder than we found this issue. Let's strategize about how to fix it. Don't
Yes.
make the call
Oh.
without counsel first, right?
Interesting. Okay.
Counsel's
I'm
going to
surprised
help
to
you
hear
get a
that.
lay of the land and the full scope of what's going on.
Yeah,
and
right.
That's their job, and they'll do a great job with that before you go reporting things to the DOE.
Well, it kind of goes back to what we were talking about earlier. Having counsel that has some insight into how this machine works is going to probably increase the odds that you're able to, skate through it in a much better way. Okay, you think we have time for one more or what? We're right at time. My gosh. I don't want to keep you. I know you got a big court date today. I thought you were dressing
That's
up for the Ethicsverse, but that's all good. All right, we'll go ahead and wrap it up. Somebody in the chat said, thousands of people said, great session. Somebody said, this is the best one yet. Okay, so that's high praise. So let's get a massive round of applause for Jen and Scott. Every time you guys show up, it's like it's like a breath of fresh air. Okay, I just feel like I learned so much. Everybody absolutely loves you guys. So we got to have you back soon. Thank you all for coming. We got 2 amazing episodes next week. I guarantee it. I'll put my money where my mouth is. I guarantee it. Okay. On Tuesday, on the 17th, right after your favorite holiday, Valentine's Day, we're going to be talking about healthcare state of compliance for 2026. And then next week, we're talking about the one of the biggest risks that many of us are facing, supply chain risk in 2026, emerging threats and strategic response. So again, we're going to keep pumping out insights. We're going to keep pumping out more value for all of us to elevate our impact, elevate our careers, and really drive more ethics and more integrity into our organizations. So listen, we just broke a record. We've beaten 1,000 attendees. Okay. The Ethicsverse continues to grow. We are trying to break 2,000 now. Okay. So you got to share it with your team. You got to post on LinkedIn. We have to continue to grow this community because as more of us join forces, as more of us share our insights with each other, as more of us learn and get better and better, the impact that we can have and the elevation of our profession is just going to continue. So love you all. Thank you for joining. We'll see you next Tuesday and Thursday. Don't miss it.